Okay, guys, sorry I didn't worry about the intro or anything because we are live here at the Massachusetts Supreme Court. Arguing for Karen Reed, we've got
Court, all rise, please.
Because as y'all probably know, Jackson and Unetti technically are witnesses because they provided affidavits in regards to the juror statements. So,
Hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
The way that I love, they still do the hear ye's, and that they still say God save the Commonwealth. This just makes me happy.
Okay, good morning.
All right.
SJC 13663, Commonwealth versus Karen Reed.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury.
Just to refresh everyone's memory. Okay, so after the trial, and there was, a lot of aftermath, right? We were covering all of it. Where I stopped covering it was when Judge Bev denied it, the motion to dismiss, because honestly, it made me too angry that I couldn't deal with it. So I did not cover that motion to dismiss, when it was denied, and but I did cover the motion itself and everything leading up to the motion. So they had made a motion to dismiss charges, and they had several different grounds, one of which was manifest necessity. Another was that had to do with the, now I'm trying to remember. By the way, guys, I've been really, really sick, and I think I still have a slight fever. So I had it in my head, and now it's just, hold on, I'm just trying to make sure I can still think straight here. I wasn't even sure if I was going to be going live today, but I saw this was happening, and I was like, I got to do it. So, so it was the manifest necessity, the fact that they weren't given time to, I think this was under that same umbrella, they weren't given time to respond when Judge Bev declared a mistrial. They weren't allowed to read the juror jury note that last time around, all of those things. And then there's, of course, the jurors coming out afterwards and saying that, it was a unanimous not guilty, and that they were not polled right on the different counts. And one of the things that I thought was one of the biggest issues was the jury instructions and the way she read them, which I guess these are the Massachusetts, standard jury instructions. But the way that it's read, and we covered this back in the day, is such that it makes it sound like, if you read the instructions and follow them by the letter, it makes it sound like unless you can have a verdict for each separate charge, you should come back with, it's a mistrial, basically. It doesn't allow for finding a verdict on one of the 3, in her case, it was 3 charges, or 2, but not all. So anyway, those were some of the issues that were raised by the defense in the motion to dismiss Karen's charges in wake of the prosecution moving or announcing that they are going to retry her. And of course, Judge Bev flatly denied that. So when they went to appeal it, their appeal went all the way up to the Supreme Court. I think this is actually pretty quick. This is being heard before the Massachusetts Supreme Court. So they are appealing. What the appeal is here, they're appealing Judge Bev's decision. They're appealing Judge Bev's decision. So essentially what this is coming down to is if they make their same case before this Massachusetts Supreme Court, and they're like, yeah, this is legit, they're going to, they have the power then to overrule Judge Bev's decision and to then, grant this motion. Okay. So now I don't know that they will make a decision today or that they might need to confer. More than likely they will, but we shall see. As we know, if we know nothing else, what we do know about Massachusetts is nothing is done normally there. So it's hard to predict what will happen. I am just glad that there are cameras and we can watch this. So also shout out to Super Planner Girl.
Jury reached
Thank
a
you.
unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that
Oh, wow.
the jurors who contacted the DA's office are different people
Wow.
from the ones who contacted yours?
Wow. Coming right out, interrupting him with a question right off the bat. Holy mackerel.
Don't have a basis to.
Okay, so when you say 7 or 8, that's
Boy.
speculative?
Oh, boy.
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 and could have been one of the 7.
Okay, so you're not
contacted the
representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2.
Right.
And that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court,
Right.
at which we contend the probability, if not the certainty, that voir dire would result in proof that there was a final and binding.
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Oh, wow.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be.
Let me just say, Rule 27, do you guys remember? Thanks to Dr. Bob, we studied that rule in depth, like just to the greatest extent. That's the Rule 27 as in Rule 27B. I'm sure you guys remember. So we actually know the rule he's talking about because we studied that at great length. So let me back this up just a second. This is interesting that they're interrupting him like this.
A general verdict returned by the jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element,
Oh boy.
the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case.
I mean, y'all, not like I can say that I can know better than a Massachusetts Supreme Court justice. However, what he said is part of the Rule 27, but it's not the entire rule. And the other part of the rule says that and we studied this, that when there's more than one charge, that the judge must ask the jury about a verdict on each charge. And that's the whole thing that Dr. Bob pointed out. And she did not do that. And that was not in the initial part of the rule. That was in like the notes for the rule, as in like the part that was added on or whatever. But still, he's not mentioning that. He's mentioning only the initial part.
Case
I'm nervous.
Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case.
Look
We had to decide what.
Look at this lady right here. I moved to the subtitles. Look at this lady. She's looking at him like, dude, are you freaking serious? This is wild. Like maybe does the apple not fall far from the tree here? Like
Was that a procedural error, or was it a judgment on the merits? And we decided
is Judge Bev really, is this just like par for the course? Like what is happening?
whatever the judge said, it was a procedural error. That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
But that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered.
Right, he's asking for a voir dire. This is what they've been asking for a long time. Well, okay, so what they were saying before with Judge Bev, when they made their motion, it's all coming back to me now. I'm still in my slightly fevered state. But what they were saying to Judge Bev was, when they made their initial motion, was these charges should be dropped. However, if you don't see it that way because you lack reason and common sense, essentially, right? I'm paraphrasing here. I'm adding that in. Okay. If you don't see it that way, at the very least, we need to, then the alternative would be to voir dire the jurors and to bring them in. And remember, they talked about this and they talked about how there was a whole thing about it, right? Like, this is so problematic and blah, blah. And it was like, look, and I remember everybody saying, and it was so funny because everyone referenced Murdoch, right? How you can do it. And they did it in Murdoch. It was way after the fact. What, like a year after the fact or something? And in this case, it wouldn't have been, but when they were talking about it, it wasn't but a month or less. So they want to, so that was the alternative to dismissing, like, because if they're going to drop all the charges, then voir dire is not necessary. But it's like, if you're not going to drop the charges, voir dire, bring the jury in and poll them like you should have done initially. That's the argument, because they are so certain that they're all going to say that they were unanimous, at least on the second-degree murder charge. And to answer Fender's question, also, I'm happy to see you, Fender. No Judge Bev, because this is the Massachusetts Supreme Court. So this appeal bypassed the appellate court. So remember, so they had their motion to dismiss the charges. Judge Bev denied it because, of course, and this bypassed the appellate court, potentially because they already have another trial on the books for, what was it, January, and so this would move it along. But this isn't very typical. Typically, it has to go through the court process. And normally, what would happen is if you appeal a judge's decision from the trial court level, which is what Judge Bev is, that appeal would go to the appellate court level. And then you can appeal that decision, and that appeal would then go to the state Supreme Court level. This bypassed the state appellate court and went straight to the Massachusetts Supreme Court. So this was really fast to get here. This is huge. That's why I was shocked to see this was even happening. So Marty Weinberg is here again because David and Yannetti are technically witnesses because they supplied affidavits to support the juror statements. And so that makes them witnesses. So Marty Weinberg is here arguing in front of the Massachusetts Supreme Court. And these justices so far are being difficult, but that is pretty par for the course. Right. Well, okay. Yes. However, just when we say precedent, let's just be clear. Let's be clear. So precedent. So I think when you say precedent, Pender, I think what you mean is it's happened before, which is true. It has happened before. And that's not the first time. That's just a recent example that people could recall. But just to make sure it's clear, there's the difference between like the way we would colloquially use the word precedent and legal precedent. Precedent in the legal sense means case law or a decision made by a court, okay, a judge, that is binding upon the lower level courts below it that have to follow it. Okay, so just want to make sure that's clear that, in other words, while it does set a precedent that it can happen, that's not technically legal precedent in terms of they have to follow it. Because what happens is, because that wasn't really a ruling like that. It's irrelevant. Like what happens in South Carolina is irrelevant to what happens in Massachusetts in terms of binding precedent. Now, case law from other states within the country can be persuasive authority. So, as in other words, it's like you don't have to follow it, but you could use it to support your argument. But it's different than mandatory binding authority, which comes from the same state and a higher court level within that state. So yeah, hopefully that makes sense. I know, and that's the thing. It is weird to me that they're interrupting him already. In my experience, the way that usually it works is they've got like a clock, like a timer, and he's got like say 5 minutes or 10 minutes or whatever it is, like uninterrupted, go. And he's practiced his argument. He makes it in exactly that time uninterrupted. Then the bell goes off and then they start with their questions. This is weird. I've never seen it like this before. But again, you know, everything varies by the state. Okay. I see. So you were using it in legal terms. No. So that would only, so good question, Fender. That would only apply to other cases in South Carolina in terms of having to follow it for precedent. So yeah, so hopefully does that make sense? So when you're talking about the United States Supreme Court, so SCOTUS, right, the United States Supreme Court, that is binding on every court in the country. That's the highest level there is, okay? Like in terms of your binding authority and what we have to follow, the first is the Constitution, okay? Second is the Constitution and like U.S. Code. Okay, so that's your statutes and your Constitution. Then you have the United States Supreme Court. That's binding on everybody. Whatever decisions are made there, people have to follow. And then after that, it breaks down into depending on if it's in federal jurisdiction or state jurisdiction. So because then from there you go into like your federal, like would be like your Fifth District Court of Appeals, and then your United States District Courts and whatever. And then if the breakdown below the U.S. Supreme Court in terms of the state level goes down into the state, goes down by state. So you'll have state Supreme Court, you'll have your state appellate courts, and then you'll have your state trial court level. So it's almost like a tree, right? A tree, like a Christmas tree or something, okay? And like at the top of the tree where the star is, say, like that's your U.S. Code, U.S. Constitution, and the U.S. Supreme Court. And then it branches off from there. And then it's a little bit more complicated without a visual way to show you guys. But basically, the way it works with the branches, right, is if something happens in South Carolina, that doesn't set a precedent for other states. It sets precedent for other trial courts in South Carolina in terms of having to follow it, if that makes sense, for binding case law. Is the election, I voted, so I've been really, really sick. I don't know, is today, do the results come out today? I voted really a long time ago. It was at the beginning of the I voted at the beginning of the Sarah Boone trial. So I've been really sick, so I don't know where we're at with that. If the results come out, I don't care if people talk politics. I just, I'm not worried about it. But I'm glad it's going well with your new job, though. Did that come out, Super Planner Girl? Or is that for real? How have I not heard anything? Well, I guess I can answer that because I've been in a fever state. Is that for real? How have I not heard from my mom? Oh, what? Anyway, okay, so are we sure about this? I feel like I'm having a hard time wrapping my head around it. Anywho, okay, so, but I'm glad your new job is going well, Fender. Let's get back to this here, right?
That this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
Doesn't Fiddler caution to not inquire into to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count?
I missed that part because I'm trying to process the news that about who. I had always promised I would move if that happened. So let me back this up. If there's something about racism,
Preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the
no.
recent jury declarations demonstrated that there was facial ambiguity in those communications.
Yeah.
Yes, they related to a lack of unanimity, to a deadlock about charges.
Facial ambiguity. I think you heard racial. It was facial, I believe.
The count two by itself, read vertically, had multiple charges. Horizontally, there were three separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling with manifest necessity.
The thing is that anyone that y'all remember when we covered those jury instructions before they were even deliberating, or maybe it was when they had just started deliberating, but we went over those jury instructions and the verdict form at length, and we looked at it and we said, here's the problem. If they go verbatim of what she says, blah, blah, blah. And we basically predicted it because we were like, look, here's how she says it. They have to have something on each charge. And we said, like, this is the problem. And I remember, like, Dr. Bob, for example, saying, well, that's not how it's supposed to work. And I was like, yeah, but if they follow the instructions literally, when I say literally, I mean literally, then that's exactly what they will do. And so it's interesting that when they got a chance to read every jury note, but then when this last jury note came in, she didn't let them read it. She just went ahead and made that decision. It's interesting because I feel like this should be obvious. Like when you look at the jury instructions and you look at the note and then you look at what the jurors are saying after the fact, this should be obvious that's to me, that's the biggest issue that could be fixed, right? That doesn't rely on argument, that doesn't rely on opinion. It relies on literally look at the literal wording of these jury instructions, and it's problematic. And that can be fixed. Anyway.
No opportunity for a defense lawyer to make arguments about options.
The ambiguity was in the verdict slips, which are different. It's twofold. The verdict slips were a mess because it was really confusing the way those were worded. But the jury instructions were not changed. The jury instructions were ambiguous, and we pointed that out from the get-go before they even had voiced any issues. That the way it was worded was like the way it was worded, I'm paraphrasing, was like you have to start with the lead charge. The lead charge here is second-degree murder, okay? And they're in order. It's like the instructions tell them how to approach the verdict slips. They can't just fill them out willy-nilly. They have to go as per the instructions. And the instructions say you have to start with the lead charge. And it's like, if you can't get a verdict on that, it's like, oh, I know, how did they word it? I'm trying to remember. And again, I still have like a fever, but it was something akin to the effect of like, you have to have, the thing that was the clincher was where it said, unless you have a verdict on each charge, don't fill out the forms, is what it said at the end of it. And I highlighted it, and I'm sure it's timestamped because I was like, that's huge. That makes it sound like they can't only return a verdict on count 2 or count 3, but they need a verdict on each one. So anyway, yeah, hopefully that makes sense. So it was a mess all around.
The declaration of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying,
Oh boy.
we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words deadlock.
Of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best, it's exhausted, it's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Commonwealth versus Enid Brown, where the jury was sent? The jury goofed, essentially. There was a miscommunication between the clerk and, you know, the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge.
But I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do, the lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
So I remember this very well, and I see what he's saying. You guys remember how quickly this all happened? Like, we heard from the jurors and they said that they were like ushered out, like they were like basically kicked out. Like Judge Bev didn't even like talk to them. They were like rushed out in a flurry, and they were all shocked, and no one asked them anything, is what they said. But then after that happened, it was not long before they started with the scheduling to set the date for. And I remember commenting that even Lolly seemed really stunned. And I pointed that out at the time we were covering it live. But this is what he's saying is like, at that point, why didn't the defense say anything? And he's right. The defense didn't say anything then, which is unfortunate because this could be the linchpin in this entire motion, where the problem is that, and this is actually kind of a fair argument or a fair question because he's right. Like, in other words, this is giving them the benefit of the doubt that they didn't really have time before. He's right. They didn't have time, right? Like they did not have time to do anything. But what he's saying is, at the very least, when they go to do the scheduling, which was right after the mistrial was declared, there was time there. And the problem is this, is that he's right that there was time. And the problem for the defense is that by them not saying something on the record then, it makes it seem like they waited until they heard from the jurors to then say there were issues. And that's the problem, because that's like backwards, right? That's like putting the cart before the horse, as it were. Like, it's like once you find out that jurors were like, yeah, not guilty, then you're like, oh wait, there's problem. Like, that doesn't work. So this could be the real clincher here in terms of this argument.
It's an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds, if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question and has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity,
Right.
which is illuminated by the
And
jury
really,
declaration.
that is really more akin to the verbiage that's outlined in Rule 27B. So
That there were two
Why-
ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes 2 previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tuey-Rodriuez charge to be given. I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument. No.
So this is going back to she's leaning now on one of Judge Bev's big things that Judge Bev kept saying, and the prosecution, that initially, early on, they argued forcefully that the Tuey-Rodriuez instruction be given. Now, when that happened at the time, I pushed back on that because I thought there was some sort of miscommunication. I don't remember all of the circumstances now, but I'm sure it's time-stamped, and I pointed it out at the time that there was something funny about that. Like he initially said one thing and then switched it, but I don't remember all of those circumstances now. But now it's funny that that's another one of the big things that the state and Judge Bev have relied upon to say, well, hang on, you really wanted a mistrial all along, type thing.
No additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks.
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that.
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a Tuey instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all 3 notes are ambiguous. The defense.
That was not the argument you made below.
Oh boy.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was ambiguity.
time, not at the motion to dismiss, at the time.
They had no opportunity at the time to.
First note, was there an argument made?
So what's happening here? Wow, they're getting right into the semantics of this. So if y'all, I can explain this if you're curious what's happening here. So she said, where is the record of what happened in between? So I think it was what? It was after the second note, right? Where apparently, that they asked for the Tuey-Rodriuez instruction to be read, right? I think it was the second note where they asked for the Tuey-Rodriuez instruction to be read, which is essentially like saying, okay, that the defense is fine with the mistrial or asking for mistrial. It's not quite the same, but it's like that's kind of the expectation, because what would happen after that, if the jury comes back and says we're still hung, is there would be a mistrial. Okay, so what she's saying is, what is the record that happened in between note 2 and note 3, where now note 3 comes out and you're saying, no, we don't want a mistrial, because again, it's implied or understood that if you want the Tuey-Rodriuez instruction to be read, you're saying you're okay with a mistrial, basically, right? And he was saying, well, the record is the fact that they went and deliberated for several more hours, blah, blah. And she's like, no, I'm asking for like the record or whatever. And then he basically said the same thing. And then he said something about the juror notes being ambiguous. And then she's like, but that's not what your argument says below. And she's referencing what the trial lawyers, aka Jackson United, said at the time when this was all going on. And now he's saying, I think he's kind of, I understand what he's doing. I think he's like, because he's trying to say, he's referencing the third note, which they never got to see. And he's like referencing that, knowing full well that she doesn't mean that note. She's talking about the first two notes. And so she's like, no. I'm talking about the first two notes. Let me back it up a second. So hopefully that makes sense. But this is really interesting because they're really, this is what they do at the Supreme Court, right? They really, they go hard in the paint. As it were.
Concerning ambiguity.
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was
time,
ambiguity.
not at the motion to dismiss, at the time.
They had no opportunity at the time to.
First note, was there an argument made
There.
concerning ambiguity in
First
response to the first note reporting impasse?
No, there was a request for TUI.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority? Why would that be the critical
Oh
moment?
boy,
Because before that, there's at least an impasse.
that was a big thing in your opinion, and without citing any legal authority.
On one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may
27B, guys, he said it. 27B.
a
Yes.
request of a jury
Yes.
whether or not they've reached any decision on any of the other counts.
And we went over this. It says may initially, but then later on it says must. It says may and then it says must. We went over this.
Porter's
What,
notes.
at the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they
Nothing.
said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tuey-Rodriuez, and the prosecutor said, not yet. And she said,
Okay.
yes, no, not yet. And then there was the second note where again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tuey-Rodriuez, and the defense counsel says, yes, go ahead and give Tuey-Rodriuez. And she considers that alternative and gives the Tuey-Rodriuez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not.
So here's
And
the
at that
guys, here's the thing. What I find that's really interesting about this is that they are really examining the actions and the order of the actions of the defense attorneys and not the issue itself. Like for me, it's really interesting because for me, the issue itself is really clear. The jury instructions need to be fixed. Point blank. This jury instructions need to be fixed. And this jury needs to be polled. Okay. Great question from Fender. Why does the eloquence of the note even matter? Yeah, no idea why they keep bringing that up. It's stupid. But the jury, they need to fix the jury instructions, and the jury needs to be polled. Okay. And this would then, if a decision was made along those lines, that would set precedent. Again, using that word, that would set precedent for the rest of the state. Okay. However, if the jury instructions are changed, that would actually come from the legislative branch, so that'd be different. But anyhow, but what they're doing is I understand, I can see what their train of thought is here, because they're not examining those issues, because their first issue is, whether we agree with it or not, like their first issue is examining the defense counsel's actions. And really, it kind of, in a way, to me, comes down to good faith and credibility in a way. And let me explain. Because the reason they're diving so hard into these things about what did they do after the first note and what did they do after the second note is because of the fact that they're really relying on that whole thing about they requested the Tuey-Rodriuez instruction, and that it wasn't until after these jurors came forward that they came forward and said, we want a mistrial and whatnot. And so that to me says that these Supreme Court justices are questioning whether or not they just were using that as an opportunity type thing, right? Because of the fact that they didn't make a record sooner. And that's where it's like, whether that's what they were doing or not is almost irrelevant. It's like the shame here is if they'd made a record sooner, like that one dude said that I pointed out that I thought was really smart. The one dude who said, what about if they had made a record when they did the scheduling? If they had just made a record then, this would all be moot. This would all be moot because it would have been before any jurors came forward. And I think that's why these justices are questioning the order of events here with the defense attorneys and not actually, the issues that we've all been talking about and what is really at issue. They're not getting there yet because they're like, is that even relevant, right? Because like, if this is not in good faith, does that hopefully that makes sense. Right. That's it. Right. And the thing is that I would not agree. The only place where I can agree with that is that I wish they would have said something at that scheduling, because that's the only one where I can say, no matter who you are, they would have had time to say something then. The idea that they could have voiced their objections prior to that, I think is not reasonable. But when they went to do that scheduling with Judge Bev, and at the end of the day, they could have said something then. And I wish they had, because that would have changed everything if they put something on the record then. And that's part of it, right? That's why you put things on the record. Because if you don't put it on the record, you can't argue it later. So people put things on the record.
At that point, she considered the alternatives. Let them continue to deliberate, give the Tuey-Rodriuez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. Imagine if you want a mistrial, you ask for one.
Imagine one person going up against, how many is it up there? Like 10? Imagine one dude, like it's like being in front of a firing squad. I mean, God.
The rule would be that anytime there's more than 1 charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you?
There's the must. I've been waiting for that.
At an impasse as to count 1? Are you at an impasse as to count 2?
Finally, addressing Rule 27B. What's she going to say?
As to count 3? That's the rule?
When there's a multiple count indictment,
yes,
that's the rule as described by the reporter to 27B, which is a trial court.
Thank you, guys. Finally, I have been waiting for people to really recognize this is the thing.
Right make that inquiry before ordering a mistrial.
I thought it was a May, Mr. Weinberg.
The May was in the rule. The reporter's note says must. I would argue.
Hold on. You guys, hold on. Did you guys hear that? Hold on. You know what this is? You know what this is? You know what this is? Guys, what was it? 10 minutes ago I pointed this out. Hold on. I get to do my thing. I can't even believe it. Remember what I said? I said it says May in the initial one, and then in the reporter's notes it says must. Hold on. See, check this out. Wow, that's awesome.
That's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought it was a May, Mr. Weinberg.
The May was in the rule. The reporter's note says must. I would argue the May relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
In the ordinary case, the foreperson will say, we've got a verdict.
Well,
on
Prue, I dare say that some of us here know that the languaging of that rule better than at least one of the Supreme Court justices of the Massachusetts Supreme Court. So
It's 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates.
what I think happened there is that where's prosecutors, by the way? Hold on.
Court has to comply with the guidance, the principles, the mandates.
That counsel for the state? Where's anyway, where's the prosecutors? Anyhow, so what not my take on what just happened is that Stern fellow who was talking about Rule 27B and thought it was may, when it's may, then must. He completely changed the subject away from Rule 27B, which is such a shame. They should have stuck with that because I think that's really the heart of the argument here, and he just completely changed the subject.
And Taylor, here they complied with neither one of them.
And that's absent any other evidence.
I know.
And
And Fender, I agree, and that's the thing, right? The must is that you should have polled the jury and asked them if they had a verdict on any of the charges, and she didn't do it.
deliberations go in the notes that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of two interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-Tuey of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter
of
of
these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3
So
different options.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but
Yes.
there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberations.
Okay, this is back to Rule
Let
27B.
me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why?
Okay, first of all, I just wanted to be clear, there's 7 justices. But also, I think this is the first time we've heard from this fellow, but what he's saying is that he's getting now to the idea of voir dire the jury, because what Judge Bev said was there's no way she could possibly ask them without infringing upon the province of the jury and getting into their deliberations, which, as we all know, is bullshit, right? So he's asking about that now. So kind of changing topics.
How would she do this? She doesn't envision a way that
It's
she
annoying because they were back on 27B and now it's changed topic again.
could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on
My
that.
thought process, one is that this court has the option of essentially informing the court what questions can be asked. And 2, if we're going to delegate.
Require follow-up questions. And unlike extraneous influences where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. One, did you take a vote on count one? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that gonna, the jury can change its mind, right?
Could, but there's no.
But isn't that gonna result in asking that type of question? When you say final, if you don't get your way on two, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror, they served for months, says to anybody, to the court, to the clerk, to the court officers, to the prosecutor,
Well,
wait, I didn't agree.
They also don't write in saying we agree with the other five or anything to that effect. They're silent as their deliberations are supposed to be silent, right? See?
But it's an almost unprecedented amendment issue. The jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered?
I think this is their best bet, is arguing for the voir dire.
If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Ms. Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important.
And just thinking back to Rule 27B, the only thing that the defense maybe could have done to preserve this for the record, again, going back to the idea of saying something when they had the scheduling conference at the end of the day, if the defense had said something like, Judge, what about Rule 27B, and it had at least mentioned that, then I think that would be a lot different in terms of voir direing the jury at the time, or even at least getting that on the record. Because again, I think voir direing the jury is the best argument. So.
Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an
Right, but
external
when it's an
source.
extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask,
Just like
why did you vote not guilty? Why, what led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not
juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
It's a
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannoni, if conducted, that was my vote.
I think what's going on here is she's saying because they could only find her guilty of count 3 if they found her not, hold on. No, they could have found her guilty on all 3. So I don't know what her point is here. Actually, because I was thinking she was saying that they would have had to have found her guilty on count 3 instead of count 2, but that's not true. They could have found her guilty on both. So
it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to
you don't want to
return a
on
verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slip.
That's it.
And
That's it.
Seems to me, at least please correct me. Why isn't this?
What she just said is the whole thing. That's the whole point. That was the part I was trying to quote earlier and I couldn't remember it exactly word for word. That's it. They have to check, they have to have a final verdict and check a box next to each charge. That means each charge. That's the problem right there in the jury instructions.
This post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions. We have a long line of jurisprudence that says we presume that the jury follows the instructions.
And there is cases where when mistakes
Here's
are
what it
made
is.
by jurors, where they don't fill out the verdict.
She's saying that she's focusing on the part that it says a final verdict, as if they weren't conclusive on counts 1 and 3, which the jurors that have come forward have said they were. The part that she glossed over is the checking a box next to each charge. And we know they weren't conclusive on count 2. So hopefully he'll point that out.
Slip accurately. The
That's not this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
before you shift back to that, what's the best case, best federal case? Because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after What's, if we want to go back and read one case that's
This
going to
is,
do what you want us to do, but
This-
what's the closest
it's
case?
actually a Mississippi case. I think it's named Martin versus
That's
State
a-
that the amici
That's a
brief
state court
brought us
case, right?
to, where they read the
It's a state
newspaper.
court case,
Yes,
right?
it is.
Any federal cases, because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
well, this court has a long history of applying
We don't
federal
have any
constitution.
cases except extraneous influence cases. I'm just again, your chance.
You do
Best
have,
case that we should look at for you.
you do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial
Again,
bias.
that's extraneous influence. It's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn
There's-
to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well,
This is-
actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and I
So the
urged it.
jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules of Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tuey-Rodriuez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tuey-Rodriuez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open, the jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
The judge said they're at an impasse, bring in the jury.
bring in the jury and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object.
but you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury.
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were an impasse, bring the jury in. Yes, that was possible, but to
What was
extinguish,
possible?
to ask to go to the bench, but
Yes.
this court.
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose the burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After a
correct?
careful consideration of all alternatives and after giving
So
the
that may
defense an
explain why
opportunity.
perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted the verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives Tuey,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Right, and in
But
face
they
of that,
didn't know what the note
you
said.
think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all 3 counts? Is there any,
And
did
that-
you consent
that's
to
the
deliberate
question.
on any count?
Was it an
that
all?
you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that
Right.
would have
That's the thing.
actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
And the statutes, again, is
Yeah.
is a may, correct?
The statute says 27B says a court may.
May
make
and then
that
it says
request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, the number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in
For
combination
getting the must.
with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence, where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you. Okay, Attorney Schillinger.
So this is arguing for the state. This dude.
Good morning, Your Honors. May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
So this is really interesting, because now we're going to see how much of a hard time do they give him versus Marty Weinberg, right? This is interesting.
Did inform counsel that the jury was at an impasse.
Wow.
Argue. At this point, it is clear
Wow.
that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tuey-Rodriuez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
Rather
a part.
than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues.
So it's not inherently coercive. If
So
the judge has a discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion. And that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A.
You're right. He does sound just like Ron Moore.
Continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits, now 4 or 5 days of deliberations. They've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the appellate process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
This is a great example of the law. And what do I mean by that? In terms of the law has a lot of overlap with philosophy, which I love. And so what we're seeing is how they are arguing against both sides. Like, isn't this fascinating to see? I mean, you're really seeing them make the exact opposite argument now that they're dealing with the state. And it's just that this is fascinating to watch. But this is the heart of how legal minds, especially when it comes to, if you're a judge, for example, like on a Supreme Court, this is exactly how it works. You have to be able to see both sides of an argument.
Certainly, Your Honor. And I think, in hindsight, seeing, the quote unquote remarkable turnaround of the defendant's position, would it have been better? Would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
Find consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first 2 notes. And what was the defendant's response
Wow.
to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from that's different. I mean, they want a verdict. Because they want Tuey-Rodriuez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to.
Oh, fuck.
Waiting for the jury to enter a room.
Did y'all hear that? That is huge. He said just because they wanted Tuey-Rodriuez doesn't mean they consented to a mistrial. That is really good for the defense, because from what we've heard so far in argument is people saying, because they did, Judge Bev, and the state saying, because they did consent to Tuey-Rodriuez, they were consenting to a mistrial. And he's saying that's not the case. Interesting.
The room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's in an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room. And even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room. And at that point, the judge did still consider counsel's arguments. And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
Lack of consent is not.
I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan.
Mm-hmm.
So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Oregon is an example of that. Judge comes in, abruptly announces trial judge is unable to preside. I'm declaring a mistrial. There was no indication there that, you know, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not.
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Wow.
Because, Your Honor, not just what they argue, but what they argue.
Because Tuey, you know, there's two results of Tuey. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just
Pushing for a verdict, and I think that's what it was.
That final push, as the Tuey-Rodriuez instruction says, you need to check yourself. One side has the burden of proof.
Right.
It's very favorable in some instances to a defendant. So how can you stand up here and say that they're pushing for?
They could have been pushing for a verdict. Great point.
Perhaps as to just Tuey-Rodriuez, although it's a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Yeah.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue. There's been due and thorough deliberation. I think the exact quote is, "We believe there's been sufficient time." Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a Tuey instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Right.
Do you need
That matters.
consent in order to?
That matters because that's a huge distinction, right? Because if the argument from the state and from Judge Bev before was, well, they were consenting to a mistrial because they pushed for the Tuey-Rodriuez instruction, but what he's saying, this justice is saying, is that no, not so fast. Pushing for a Tuey-Rodriuez instruction actually means they could have been pushing for a verdict. Then that right there changes the whole idea of this manifest necessity, because if they did not consent to the mistrial, then that's a big problem for the state, and that's good for the defense. And if it's saying that, well, them pushing for the Tuey-Rodriuez instruction means they were pushing for a verdict and not a mistrial, then there you go. Then there wasn't manifest necessity. In other words, they didn't consent, and they have to consent. So
To win.
No, Your Honor, there was manifest necessity for the declaration of the mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
keep reading.
Yes, I don't think that the judge abused her discretion in declaring a mistrial.
That's so funny, because like I just said, right, about the consent with the manifest necessity, and this judge just asked that question.
Well, for manifest necessity based on the jury deadlock in this case, for the reasons that we have discussed and we're discussing.
But counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this. And perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear
Wow.
from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps.
Oh,
But
boy.
the judge's
Oh,
determination
boy.
here,
Oh, boy.
which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury? I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs. But did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted, there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind.
And dude, I put up a big stink about that the whole time. I was like,
But
why?
so I see your point on the note is so compelling that they've worked this to the end. Then the problem comes when we get this new information that's somewhat inconsistent with that the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already.
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged. They've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their
Well,
deliberations.
that's a separate matter. You said that,
Correct.
you
Oh,
can't
David,
bring this
they're,
jury back. You can bring them back for post-verdict inquiry.
Well, it's one.
Jackson.
Under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a verdict that was never
What Mr.
returned.
Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
it's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury?
Yes, ma'am.
decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations. And I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
Or
sent
threats.
back jurors
Yeah.
on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's
Our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited
Thank
question.
you.
And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take Your Honor's point.
However
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
We asked,
Did
do
you-
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
no, but again, I want to reemphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say,
Is that Justice George asked your brother counsel about Bluford? Is Bluford the answer for you, that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
would argue that it is, and I actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement, where it said, you know, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Is Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser includeds or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Court, all rise, please.
Okay, so let's see what happens here if they come back. Or is that it?
Court stands in recess, please exit the courtroom.
That's it. That's it, guys. Looks like the feed is still going, but so they said, let me just make sure. That ended pretty abruptly. Let me just make sure they didn't say something about coming back.
If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Court, all rise, please.
Yeah, that's it. Wow, abrupt. Well, there you have it, guys. So apparently they don't. Fender's asking if they rule from the bench. Apparently not. So it's interesting that they kept the feed going, though. I mean, it's still going live, but you know, I don't know. It doesn't look like that's for any particular purpose. So yeah. Now if something happens and they do come back, I'll pop back on, but it looks like they're going to take time to discuss everything. I mean, it doesn't really surprise me in this case because it is a huge decision as there's a lot of information to take in. But I do appreciate that they really grilled both sides as they should. And so yeah, now as for what else is happening here, tonight I will be covering the last filing from the defense for Idaho v. Koberger in preparation for the hearing that's happening tomorrow on the death penalty. I've been looking forward to this for quite some time. And depending on what time that hearing is, I may be able to cover it live. Other than that, I'll be covering it probably tomorrow night or maybe Friday, just depends on how long it goes. It might be like an all-day thing. But we will be covering tonight that motion to strike the death penalty from the defense. And And then I think I have for Friday the next episode of the Casey Anthony trial, where we hear from Dr. Arpad Voss. So this was very interesting, wasn't it? And we'll keep an eye out for any ruling from this Massachusetts Supreme Court. But y'all, thanks for being here. Thanks for being a squirrel, and I'll see you guys on the next one.